A few weeks ago, I walked into court and I sat in on a trial, and I learned just yesterday that the attorney who was representing the injured patient in this medical malpractice case was able to achieve a $40 million verdict on behalf of his injured client. Would you like to learn some of the observations that I made while I was in court watching this trial for a short period of time that I think made a huge difference in the actual outcome of this case? Come join me as I take a walk around the neighborhood as I share with you some of my observations. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I happened to be in court a few weeks ago, and I had to deal with a conference on one of my cases. And now, when I was done, as I will often do, I will go from courtroom to courtroom to see if there's any trials going on. If there is, I will simply walk in, sit down in the back, and start to observe. And by the way, in case you haven't done it, I highly encourage you to do that because in New York, all of the courtrooms in the civil courts in New York are open to the public. And it's fascinating. It's fascinating to see a real trial in public, in person, and now to observe every single aspect of what's going on. Now, in this particular case, what happened? I walked into the courtroom and I immediately knew that there was a trial underway. How did I know that? Because the judge was sitting on the bench. A witness was in the witness box. An attorney was pacing in front of the entire courtroom. I looked to the right side and the jury was sitting there watching very, very closely what this attorney was asking and what the witness was responding. I saw to the left of the attorney's table, I saw 3 lawyers wearing gray suits, almost identical. They were all defense attorneys who were sitting and waiting and occasionally making objections. So now I recognized immediately by the questions that were being asked and some of the answers that the witness was giving that this was a medical malpractice trial. This was a case involving a neurological injury, a severe neurological injury. And I also learned very quickly that the witness who was testifying was a neurosurgeon. He looked like a young guy. And now I get the sense, just a few moments of sitting there, that this doctor really was not very experienced at testifying. He was nervous, and he was looking awkwardly at the jury, and you could see his awkward mannerisms. And that tells me that he clearly did not have much experience at all testifying. In fact, it's probably his first time testifying, given the fact that he's so young. What else did I notice? I noticed that this attorney had salt and pepper hair. He was a distinguished gentleman who clearly was very, very experienced in questioning witnesses. Now, how did I know that? Because this attorney was asking cross-examination style questions. Now, you might wonder, what's a cross-examination style question? It's one that really calls for a yes or no answer. Now, what do I mean? So in a medical malpractice case in New York, usually the first witness that we call is the doctor who is being sued, the target in the case. If it's a medical malpractice case, why aren't you putting on your injured client, the injured patient first? Well, there are a lot of strategic reasons why we wouldn't do that. And the idea is we want to go ahead and tell a story to the jury in the words of the attorney and simply have the doctor either acknowledge those statements or disagree with them. You see, a great cross-examiner, a great attorney who knows how to cross-examine a witness, their goal is to go ahead and tell the jury a story in their own words. The best goal is to now get the doctor on the witness stand, not to tell a story, but to simply either admit or refute the statements that the attorney is making. And now you might be saying, wait a second. How is the jury going to understand what really happened if the doctor doesn't go ahead and sit and explain? I'll tell you why. An attorney who brings a lawsuit on behalf of an injured patient, we are known as the plaintiff. And as the plaintiff, we have what's known as the burden of proof, which means we have to establish that we are slightly more likely right than wrong than what we are claiming is true. We don't have to show with absolute certainty that what we are claiming is correct. If I were to go ahead and allow the defendant doctor, the doctor who is being sued, the opportunity to tell a story, to narrate exactly the series of events that occurred, do you think he's going to be more favorable to his defense and explain away every single thing that happened? Or Do you think he's going to bend over backwards and tell the story from the patient's standpoint of why there were departures from good care and why things were not done correctly? The answer is pretty obvious, isn't it? The doctor in no way is going to testify against anything that's going to hurt him. He's going to try and excuse every single thing that happened. He's going to argue that whatever he did not cause harm to the patient. And he's going to say, I did nothing wrong. And that's usually what will happen. So in order to control the narrative, in order to control the testimony, a really good cross-examiner will go ahead and limit the doctor's answers to yes or no. Now, there are many instances where an attorney tries to do that, and now the doctor turns around and says, I'm sorry, I can't answer your question yes or no. Would you like me to explain? That is coming from an experienced doctor who testifies more than once. Why? Because now you're looking to explain, and you're doing it in such a nice way that the jury realizes, hey, why are you beating up on this doctor? Why are you preventing him from going ahead to explaining away the answers to your questions? And now when he does that, it is the attorney, the plaintiff's attorney, who looks like he's trying to hide something, and he's trying to prevent the doctor from telling the jury information that might benefit him. And in that instance, it's not a good perception for the attorney who's bringing this case on behalf of the injured patient. During questioning, the plaintiff's attorney did not ask open-ended questions. He didn't ask the doctor to explain anything. He didn't ask the doctor to tell him why certain things were or were not done. Instead, he asked him small, simple, straightforward questions that call only for yes or no. Doctor, isn't it true on this date you did this procedure? Yes. Isn't it true that during the course of this procedure, X, Y, and Z happened? Yes. Isn't it true? And he would just ask simple, straightforward questions. And that is the mark of an excellent, experienced cross-examiner. And why was that important? It was important because it set the tone for what I believe was the entire case. Now, admittedly, I only got to sit in the courtroom for about 15 minutes to watch some of the interactions that was going on while this attorney was questioning this neurosurgeon. And it was only just yesterday that I was reading that this attorney was able to achieve an outstanding, remarkable result of obtaining a $40 million verdict on behalf of his client. And I believe that this jury did not appreciate the doctor's answers as he was giving testimony as the very first witness in this particular case, and they had already begun to make up their minds, even though they had not yet heard all the other details that went on over the next few weeks. So why do I share this with you? I share it with you because it's a fascinating insight into what really happens in these medical malpractice trials, these accident cases, and even these wrongful death cases. I strongly suggest, and I strongly urge, if you have not done so, walk into any courtroom, walk into any courthouse in New York, walk into a courtroom where you see activity going on, and sit down and listen. Stay for 10 minutes, stay for 20 minutes, then get up and go see if there's another case on trial. Walk down the rest of the hallway, walk to another floor. And I promise you, it will be much more interesting than anything that you see on TV. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.